Can we start from the Court of Appeal? On Thursday, the Court of Appeal convened, like we normally refer to them, the three wise men, because Justice Ajet Nassam, who sat in the High Court on the Woyome case, Woyome was being prosecuted for fraud and causing financial loss to the state in respect of the 51 million Ghana cedis that he procured from the state. Now, as you know, Justice Ajet Nassam came to the verdict that the state had not been able to prove its case. He actually said the state did a shoddy job with the prosecution, and therefore he could not convict Woyome. So the state said that Ajet Nassam got it wrong. The state went to the Court of Appeal, and that has come really fast. Now, just Thursday, the court sat, and the three of them agreed in toto with Justice Ajet Nassam. So forget about the fact that Justice Ajet Nassam has been involved in taking some goats and has, on the back of that, been sacked. It does look like three of his seniors agree with his judgment, that the judgment is sacrosanct. Kweku, I guess I should start with you. And on this note, if you permit me, Kweku, on this note where, and I'm relying on the graphics publication because I don't have the judgments. In the graphics publication, they do say that Justice Osei, who delivered the judgment, said all stakeholders said he was entitled to the claim, unquote, quote unquote, that on this basis, and these stakeholders he refers to as the Attorney General, the Ministry of Finance, the Bank of Ghana, the Local Organizing Committee of CAN 2008, and the Building and Industry Consultants, BIC. And so you cannot bring him now and seek to try him for fraud. There doesn't seem to be any fraud in the matter. And the last point I'll read to you. On the issue of the contract, which the Supreme Court said he had none, and so that is not deserving of any payment. The graphic reports that touching on the state's claim that the government had no contract with Woyome, Mr. Justice Osei was emphatic that Woyome's claim was based on the tendering process, which was terminated in 2005, as well as his claim for financial engineering and the concurrent approval for his partners by the Central Tender Review Board. So, Kweku, the Court of Appeal is saying, they may not have put it in those words, it's saying the Supreme Court actually got it wrong.
You know, last night, and I mean it, I had to pray a lot. I'm not a very, very religious person, but I really had to kneel down and pray to the Almighty, merciful Allah to give me the strength to exercise self-restraint on this program today. And I mean it. It's with a lot of difficulty that I am going to make a submission on this particular matter. And I have to be honest with you, I'm finding it very difficult, because otherwise I might say things that may destroy myself, my own integrity, my public image and everything. I have got a copy of the judgment. I got it late afternoon. So I have to be honest and say that I haven't read the entirety. I'm sure even you as a lawyer would not have been able to finish reading. But I've done some, you know, jumping here to there to try and get the salient points. And some of the things that you've quoted from graphic are here reflected, even more emphatically so. Mr. Woyome says he's forgiving all those who insulted him or criminalized him. Well, I think it's God who can forgive. But to be honest with you, I think there's something wrong with this country spiritually. Something ought to change. All stakeholders, it's there, it's in the judgment. Who were they? See, I'll tell you something, and it's with difficulty, but this thing, I look at it in two terms. And there's the political, and there's the legal. This whole thing would not have occurred if they hadn't been that crude exhibition of political patronage. If we had not created a psychological environment that sustained the thing, a perception of some people having been victimized because of their political affiliation. That's what happened initially. That is why those stakeholders being mentioned, the then Attorney General, the Deputy Attorney General, the state attorneys, those who were at the castle, some came on this platform to defend Woyome here, regardless of the documentation that was available. It was the perception that Woyome was a victim of political vendetta by a previous government. And so he ought to be helped out of a jam. Otherwise, look, all those people, the Attorney General, the Deputy Attorney General, all those people were very intelligent, well-educated professionals who could read those documents and understand what they meant. But for some political reasons, and it's not peculiar to recent times, but it's a certain subculture in our body politic, and that is used, capitalized on, by people with some interest, always to pursue an agenda, and they get what they want. Here we are. Because of that crudity in our politics, we are where we are. It was reinforced by the fact that when we decided as a state to take action against Woyome, we also didn't balance it. Where those stakeholders, why were they not with him in the dock? Or why were they not with him even in court?
Exactly.
Well, on that score, the Court of Appeal disagrees with Justice Ajet Nassam, because Justice Ajet Nassam says these were key persons who ought to have been brought before the court, if nothing at all, as witnesses.
Yeah, but
but the Court of Appeal said you didn't need them.
No, I'm saying that either way or both. I'm looking at those things. I'm saying that let the court determine their fate. Okay? Let the court of a competent jurisdiction determine their fate. But if you take that man out alone, standing alone, and proceed to prosecute him, there's a certain deficit. And that can lead to all sorts of injuries, some fatal. But we also saw what happened in court. But in the legal aspect, I am still convinced that there was sufficient evidence before the court, both of the first instance and the Court of Appeal, not to have come to the verdicts they came to. I'm not a lawyer. I'm a layman. So perhaps I have to be cautious in the kind of submission I make when it comes to the law. Put the stakeholders aside. There were others who went to court to testify. The late Le Dosu. He was chairman of the evaluation tendering committee. They evaluated those financial instruments and documents that Woyome was relying on. Their report is there, it's on record. His own testimony is on record. And it tears Woyome's defense into strips. He was part of the stakeholders in a way, in terms of looking at the bigger picture. The police investigator, his testimony, and I have all the transcripts here, I have the full records of proceedings. The last 1.5 years I've been reading through them. Nobody, and I tell you, nobody, and I'm sorry to say this is blasphemous, not even God, can convince me that the testimony the police officer put forward did not undermine and destabilize Woyome's defense. Look, those documents he brought, those records, the Bank Austria's responses indicated those were mere papers. There was no commitment from the bank. Now, Woyome's argument is that, look here, I never said that Ghana government was giving any money or any money was put in any government account.
And the Court of Appeal agrees that he needn't have procured money for us before you pay him what you agreed to pay him for the service.
Who should pay him for what service? The Supreme Court. It is clear. Who was he representing? Osei says that he was speaking, pursuing the case on behalf of his group. Yes. Which group?
Empower Park.
Osei Invest, whatever. They had finished with him. There's enough documentation to that effect. Woyome was not representing himself. Unfortunately, Justice Osei is saying so. So what are we talking about? Why are we doing this to ourselves? Why are we doing this?
Justice Osei is saying what was paid the group, which was later paid to him, is distinct and separate from the processes leading to which he claimed.
That should be told to the Marines. That story should be told to the Marines. I'm shocked that thing is advanced, canvassed, and upheld in a court of law. The appellate court. I am shocked. What are we talking about? What is it that we are talking about? Listen, let's read the Supreme Court thing first. Now, there's a distinction, of course. I know at the Court of Appeal and the High Court, it was more the criminal issue that was at stake. I can appreciate that.
Yes, and again, it ought to be appreciated this way because some people have been confusing it.
Yeah.
At the Court of Appeal, what the job of that court was is not to do a trial or a retrial of the case. They were simply to sort of evaluate what has already happened at the High Court and to come to a conclusion of whether or not what the High Court did, there were some errors or there were not errors. Simple. That's all it did. So you realize that Woyome was not called to give any testimony in the High Court, in the Court of Appeal. Neither were the Attorney General's people and any other witness called in the Court of Appeal. So please, let's note that one.
Yes, you recall that in the earlier Martin Amidu case, the first run, the court declined jurisdiction relative to Woyome, who was the third defendant, because of the nature of his thing. But Martin went back for a review.
That's so.
And the review, the declarations that the court made, the third one is relevant in our discussions here. A declaration that the conduct of the third respondent, this is Woyome, therein plaintiff jointly with Osei Invest Management Limited in making claims upon and including the issuance of a writ of summons within the support of the second defendant. Second defendant, and receiving payments premised upon breaches of the two inoperative agreements dated 26 April 2006 between the second defendant and the government of Ghana, which are international business or economic transactions, which had not been laid and approved by Parliament, is inconsistent with and in contravention with Article 1815 of the Constitution. When it came to the Woyome thing, the Supreme Court now, upon review, and that's the basis on which he was asked to refund the money.
That's right.
When you read this whole thing, all the attempts to try and force a certain basis for Woyome's claim is inconsistent with this one. When Empower Park, and indeed we should make it clear, the records are available, that Woyome is not the owner of Empower Park. Not the so-called Togolese branch one. The real Empower Park that was working with Vamed. They won the bid that ended up being truncated. Okay? Vamed even reassigned their rights to whatever. And they indicated that why they were doing so was that they realized that stadia was what was going to be put on board and that they don't build stadia. And they were interested in the so-called hospitals and other projects, which never really got discussed anywhere as something for government to do. Look, my brother, let's be honest. I respect the courts, and I have no right to scandalize the courts. But I think I have every right to criticize verdicts that are given by the courts.
Yes.
So I respect the verdict.
That's what even the Supreme Court says you can criticize it no matter how rambunctious.
Yes. I vehemently disagree with this thing. It's making this country look like a banana republic, which we are not. It is a vote for impunity, which should not be countenanced. Yeah. And be honest with you. And if we are not careful, it can lead to a situation where people will think the courts mean nothing, even though I'm cautioning against that. Yeah. I'm cautioning against that.
Okay, Koku, hold on.
I hope
just hold on. Well, Esla, the bedding, if you put a criminal charge on anybody, is proof beyond reasonable doubt. It is not a civil matter on which the bedding is on the balance of probabilities. Do you think that from the trial court's assessment, the Court of Appeal ought not have upheld, saying that you did not discharge that burden of proving beyond doubt that Woyome committed a fraud, particularly because this is a man who came to you and said, you owe me money. You sat with him, had discussions. You had difficulty with him. He said, if you won't pay me, I'm going to court. He went to court. You went to court, filed an appearance, but you didn't file a defense. On the basis of that, he amended his rate twice and then eventually got a default judgment against you. He got a judgment for over 100 million Ghana cedis. Came to you, give me my money. You sat down, discussed with him, beat the money down to 51 and tendered a document in the court that you together with Woyome have agreed that instead of paying him the 107 or so million Ghana cedis, he's been gracious enough to agree to take 51. And so you are going to pay in 3 different tranches, 17 million, 17 million, 17 million. Somehow, fortunately, the court says, okay, pay 1. Don't pay the rest of the 2, because you had come back later after you submitted that and said you were under a mistaken belief that you didn't have a defense. Now you know you have a defense. And the court said, okay, in that regard, then pay him only the 17 million. Let him give an undertaking that if he loses the case, he will refund the 17 million. On the blind side of the court, you pay all the 51 million. You bring him now to court for fraud. You can't prove it. You have not proven it.
Somehow, I'm not surprised that Woyome has walked.
You're not surprised?
No. And the conduct of the Office of the Attorney General at the time is what has resulted in this. Because the man didn't walk in there and take the money by himself. Officials of the state, the legal officers, the legal advisor to the state, the one who is in charge of protecting the legal interest of the state, for some reason contrived to hand over these monies to Woyome.
The Court of Appeal disagrees with you when you say contrived.
I'm
sorry. The Court of Appeal says the reason Betty Modudisu gave for the payment was a good reason, because all others had agreed that he was deserving of the money.
Unfortunately, I haven't read the Court of Appeal judgment, so it will be difficult for me to make a determination of whether I agree with it or not.
That's fair.
But I am going on the facts that are in the public domain.
Okay.
And the Court of Appeal, thankfully for us, is not the final opinion on this matter. In fact, let me start by saying that I urge the Attorney General, if they are serious about protecting the interests of the state in this matter, to appeal this decision of the Court of Appeal. Thankfully, they are not the final arbiters on this. And our judicial system recognizes the fact that mistakes can be made at any level and so provides a further layer of scrutiny to enable the matter to be looked into again. I disagree with the fact that anyone sized with the facts of this matter can say that Woyome deserved to be paid 51 million. And like Kweku, you don't want to get your blood pressure up too much this morning. and so I will try and moderate whatever I say on this matter. But on the facts as narrated by you, which are in the public domain, Woyome worked with who? Who did he work with? Who did he represent? The interest of Vamed, which he claims was the basis for his claim, had been transferred to Waterville. Waterville had even been paid by the Kufuor administration for the work which they did. They had already been paid, and there is evidence on record in the court, in the public domain, by the lawyer of Waterville, who indicated that, we have already been paid by the Kufuor administration. They actually wrote to the Attorney General that Woyome did not deserve any claim. But at some stage, there appeared to be a convergence of interest. Okay, you don't talk too much about my own. I'll support you if you support me, and we can all profit. So suddenly, they stopped talking about that. But you already had that letter. We should have put you on notice that there's something not quite right. I was going to say fraudulent, but I'll say not quite right going on here, which would have alerted anyone. But somehow, my sister Betty Modidrisu and Honorable Barton Odro decided that, okay, let's look at this matter again. And even when the court had said, don't pay everything, even when the President of the Republic had said, halt, don't give anybody any money, you go ahead and you hand over or you approve the payment of $51 million cedis to this man. And the question I ask myself is, why was Woyome standing alone in the dock? Who did he act in concert with to deprive the state of these monies? And where are those people? They are untouchable because they are key members of the NDC administration. Really? Let us move beyond politicization of issues when the interest of the state is at stake. And let us try, it's difficult, I know, but let us try to think about what would benefit Ghana and not what would benefit our political tradition. And I don't care if it is MPP or NDC doing that. What I will say is the same. We are doing ourselves too much disservice as a nation when we focus too narrowly on the interest of our political, not opponents, but supporters, our cronies, our friends, and throw the interest of the state as, look, what could this 51 million cedis not have done at the time? How many schools could it have built? How many hospitals could it have built? How many toilet facilities? We're grappling with dealing with cholera. People are dying. People are throwing their children away because they can't afford 1 square meal a day. And we think it's okay for those who are entrusted with protecting the public purse to flagrantly just hand over monies and find it so difficult to get that money back. So my question is, how come Betty Modidrisu is walking around a free person? Why is it? Martin Odro actually said.
I wish that maybe one day Mrs. Betty Modidrisu would decide to speak to this topic, particularly in relation to this. And I'm saying so because I have information I'm not allowed to share. Other than that, you would find that the payments that were made in full to Woyome, instead of the first payment, you might find that even though she was the Attorney General,
she wasn't responsible for that.
She may not have approved it.
That's doubtful.
Samson.
That's of doubtful validity.
Samson, if you say that, then it makes the situation, well, I'm not even going to go into whether it's true or not, but it makes the point I'm making even stronger, that for political patronage, the interest of the state is thrown to the dogs. And yet we have people in charge of this country.
But you say the Attorney General, if it means business with this, it should go on an appeal. Forget about the fact that we are pursuing money that we are not going to get interest on, no matter how many years it's been with this individual. If you say they should go on appeal, here you are dealing with the technicality of the law. If they go to the Supreme Court, they are not now going to have the people you wish would have been called to the Supreme Court to testify. It is supposed to evaluate what has already been done and now been confirmed by the Court of Appeal.
I agree with you. But the Supreme Court, panel of 5, may look at the evidence which was adduced before the High Court in full and arrive at the conclusion that there was sufficient evidence before the court to found a verdict other than what the High Court gave.
Okay.
Without looking, calling witnesses again. The Court of Appeal looked at some aspects or looked at aspects of the case and decided that, in their opinion, the High Court judge was right. The Supreme Court may, after evaluating the evidence which was actually adduced before the High Court, come to a different conclusion.
Or it could also set aside all of the affirmation by the Court of Appeal and make an order that the trial be done de novo.
Yeah.
Okay, so start afresh.
Absolutely.
Okay.
So that is why I'm saying that there is another layer beyond which the Attorney General can go to.
So you encourage them?
Oh, I absolutely. I encourage them to go on appeal. If they don't, then it means that they are also quite happy with the situation as it is. And it will just tie in with their reluctance.
Those who somehow disagree with agree with Woyome will say this is clear persecution rather than prosecution.
Absolutely not.
It is not.
The judicial structure makes provision for correction of errors that may be made. And so if it's persecution, why do we then have a Supreme Court? Why? So all those cases which have traveled the rounds and made it to the Supreme Court, was it persecution? No. It is not persecution. It is so that the truth may actually be told. Not the truth that I want to hear, because I don't know how the Supreme Court would decide this matter. They may decide that, yes, the Court of Appeal was right. But I'm urging us to also test that level as well. So that if at the end of the day, and there have been cases which have been won from the High Court all the way up to the Court of Appeal, which have been overturned in the Supreme Court. There are countless examples of that. Okay. Because a larger number of people are looking at the evidence before the court again, and may come to a different conclusion.
Let me hear from Madam Kote and ask a rather technical question, but trust that she'll be able to do justice to it. Now, I'm going to read a portion of the Supreme Court's ruling in this matter. And in page 9 of the judgment, as delivered by Justice Dateba, retired now, he says that the solicitor of the second defendant, Tete and Co., contradicted Woyome's claim by a letter dated 20th November 2009. And he attached the letter and said it was critical to read that letter before the Supreme Court gave a judgment which led to the order for him to make the payments. Dear Madam, settlement of claims of Waterville Holdings, BVI, for rehabilitation of Ohenijan, Elwak, and Babayara Stadia. We write in response to your letter drawing attention to the claim of Mr. Woyome of Empower Park, dated the 28th of August 2009, against the claims of Waterville Holdings being discussed for settlement. Waterville did engage Empower Park to provide Waterville with financial engineering services, but the relationship was terminated by a termination agreement dated the 25th of November 2006. Power Park's claims against Waterville were fully settled and acknowledged in the agreement. Therefore, neither Power Park nor Woyome has any claim against Waterville. A copy of the settlement agreement with Power Park is annexed. Now, in this finding of the Supreme Court, it is saying that there was evidence to show that even Woyome himself had signed onto an agreement in which he was paid in full, not paid money only for the group that the Court of Appeal is now saying is distinct from money that should go to him, but money for the group and to himself. So he was fully settled. And on this basis, the Supreme Court said he was not deserving. Do you find that this ruling may give him and his lawyers some momentum to want to challenge what the Supreme Court is ordering, that pay 51? They will say, we will not pay because the evidence is contrary according to the Court of Appeal.
Well, I don't know what he and his lawyers would do, but what I know is that cases that involve monies paid to people for no work done or no work that can be seen always creates emotional problems. And that's why I guess Abdul Malik said something is going wrong in this nation. And especially when the person would come out and say he's forgiving certain people. Those kind of statements don't help the situation. First and foremost, there's nothing to show for the money that was given to him. However, and I think you did say rightly
he didn't need to have to show work done.
Exactly. You did say rightly that it was about a process. And perhaps, and that's why, and I'm glad that Esla said, well, we don't know, but Madam Betty Mold-Idrisu faced a certain situation where attorneys from her department before had not gone to court and all that, and they had let the ball drop. And therefore, here we were in a situation that we all didn't want to be in. So what I would say is that this matter has been a protracted one. It's gone on and on and on. And the last thing that this nation needs is for anyone to keep 51 million Ghana cedis for no work done, one, and then to almost always tease the rest of us that, well, I've gotten away with it. I believe that Attorney General, as she said earlier, that she would appeal, and she did appeal, will appeal again. I suspect strongly, I cannot say as a matter of fact for her, but I suspect strongly that she will appeal again. People are tired in this country of people coming up with these judgment debts for certain behaviors of other people and then claim monies that are not rightfully due them. At the end of the day, whether we are lawyers or not around this table, there is something called natural law. There is still common sense. And we talked about attitudes this morning. So we can't continue to encourage or allow people to walk away like this. Otherwise, people will even turn it into a business. That they will look at contracts, find little loopholes, and create all sorts of troubles
you may hear
to
within
make
certain
money.
circles that is what it is. That is a business.
So it has to come to an end at one time or the other. And this nation has to decide that no, we will not encourage or entertain such attitude and behavior anymore. I doubt that Attorney General, the current one, Madam Marietta, will sit back and just allow this to go on. And I do believe that even Madam Betty Mould, this is not the way she would have liked it to go. And unfortunately, like we've just heard, perhaps some payments may have even been made on her blind side as well, which makes the case worse. I hope that this will be a test case, that we would ride up the learning curve, and never again would we have a situation like this in Ghana. At the end of the day, Vamed has built hospitals, nothing near stadiums. Also, it looks like a payment was done to bring this to an end, and yet it was moved along. And many times, I feel sad when politicians are brought into this case, because I'm sure when we one day find out the truth, it had nothing to do with politicians, but with officials who should have known better and who just played other people against each other so that someone could walk away with free money. This is just my humble opinion on that.
And that also raises, the last point on which she ends, raises another issue where there are people who are suspicious even of the state and the manner in which it is going about this, where initially the state puts in the dock not only Woyome, it put Woyome and put two others. Those people were later, at the instance of the state, taken out of the trial. Some were said to have had some monies transferred into the accounts of their wives and so on, and they worked in the Attorney General's department. As we know today, those people have only suffered sort of a reprimand and been transferred from one place to the other. Okay, transferred from Accra to the Upper East region. People say, if this was not deliberate, just to let Woyome go. What was it?
I mean, I share Mona's thoughts that we've had this case ad nauseum. I think Ghanaians are not only tired, but we're getting to be disgusted. It's getting to that point, I think, from the way Kweku spoke so passionately. We can tell. And I think that the state also needs to, for want of a word, cleanse itself or redeem its image in this. Because in this, I mean, for example, as we've spoken about, why is it that the full list of witnesses were not called to testify in the court? Why? Why were key people that were involved? Yes, you said you have information that you're not able to share with us, that perhaps certain key people...
The Court of Appeal says, if you had called these people, there is documentation to show that they would only have come to confirm that, yes, we did this.
Call them.
That he should
Call
be paid.
them.
It ends the matter.
No, call them. Call them.
They are not denying the documents they have signed.
They should have been called and speak for themselves so that it leaves no doubt and there's no speculation. Because at the end of the day, the image and the reputation of the state is at stake. Initially, the judge said that they did a shoddy job. I mean, from my lay perspective, it looks at best half-hearted. Like it was just a window dressing, you know, because even the civil case, it was Martin Amadou as a private person, a private individual. And as you explained, the probability for civil cases, it's not about beyond reasonable doubt, as the stakes are not so high. It's about the balance of probabilities. And he had to fight tooth and nail. As an individual, he suffered vilification. And all these kind of things to get state money back. It wasn't even to put in his pocket. It ought to be
said that Amidou's case was a straightforward matter. To ask the Supreme Court whether or not the contracts from which these payments were made had been taken to Parliament in consonance with Article 1815, which says if we have any transaction which is of international, transaction, we ought to go to Parliament for prior approval. And the Supreme Court said there was no prior approval. So that was a straightforward issue, really.
No, I appreciate that, but my point is still that as an individual, as a private entity, he had to go and fight for the technicalities to be shown and for us to get the money back. But that determination that one individual managed to muster, the state doesn't seem, the whole state with its whole armory and everything that it has, all the attorneys and great knowledge and skill that is in that department, still, it doesn't seem like they mustered all of that to help convict Woyome. That's how it seems. It seems like it was a half-hearted job, and it goes beyond just legalities, yes? It goes beyond that in the sense of it looks as though if you're a certain person and you have certain connections and you're in the right kind of circles, then you're above the law. Yeah, that's a perception. I'm not saying that's a truth. And even indeed, if it's a perception, it's one that needs to be stamped out clearly. So for me, I just think, look, yes, by all means, I do think the Attorney General should go and go again and appeal. Yes, an appeal. But also,
So all three ladies agree that Madame Marietta Brio appear upon, and you should see the passion with which she exerted on this particular appeal. You should also have heard or seen Dominic Ayeni sitting here a day after the judgment by Justice Ajat Nassam, taking Ajat Nassam to the cleaners and stating very emphatically that they were going to get victory in the Court of Appeal.
Well, they should still go again and get an appeal. But my point now is that, okay, let's salvage the situation as is. Let's get the money back.
Okay.
Let's concentrate on, because up till now, we still don't have the entirety of the money back. You know, we're getting tired. We're getting tired.
Okay.
And also, you know, right now, we always say, oh, the meat is close to the bone. I mean, now people are chewing the bone. It's getting that bad. So therefore, let's get the money and then redistribute it in an equitable manner.
Kweku, briefly, and then we take a break and return to deal with the brochure gate, is it? What she says, what Jemima says, we have the money. We are supposed to take the money. Why are we so interested in getting Woyome in jail and pursuing this criminal matter? Why don't you forget about that? Concentrate our efforts in getting the 51 million. The Supreme Court said, take it.
Does our jurisprudence exclude custodial sentence?
It does not.
Yes,
but you have tried that twice. At least you've lost.
Yeah, they should try the third one. I support the idea of an appeal at the highest level of our court system. I'm for it. Then after that, perhaps, even if he escapes custody, and that's not my real point. The money is the money. The money is more important. Yes, but I mean, there are many people out there who could also have been forgiven and asked to bring back their goat you stole or so, and not go to jail. So we have to be very careful. Equity here is important. No, I still think there's something wrong with the Court of Appeal judgment.
Let him finish the point.
See,
you think there's something wrong with the Court of Appeal judgment?
This confusion. What is this confusion? There's a distinction between the court judgment and the petition he submitted. We are told that, look, he got the money based on a court judgment,
right,
and not necessarily the petition. The petition triggered the court case. He made claims, representation in the petition. Yes, concede that those who dealt with him did not do diligent work, my candid opinion. They may even have been doing some criminal collaboration. I said may, that's the operative word. But whatever it is ended up here. But in the court, see, Van Dosu, he was chairman of the...
Mr. Van Le Dosu.
Yes, I think he's passed on.
Yes,
yeah. Such a great guy, though. He was cross-examined by Ms. Lamte, and it was relative to the letter of support and what kind of document it was. This is the answer he gave. So in the bid process, initially, when you put in bidding for a project, because the bid is not awarded yet, so the banks cannot give you a firm proposal or credit or commitment. So they normally will give you a letter to accompany the bid to say in effect that yes, we are aware that you are bidding. This is to the beneficiary, that is the Ghana government in this matter, that we are aware that this company is bidding for this project. At the end of it, we will look at it and see whether the project is financeable or not. But let me say that this letters of support, to the best of my ability and from my experience, are not commitments. They are just letters to inform the beneficiary or the person who is offering the bid. Because after you win, then you have to go back and sit with them to sort out things. This letter is the basis on which Mr. Woyome was claiming 2% of the overall cost of the project. But there was no commitment. So Ghana government, Ministry of Finance, Bank of Ghana, none of them came into the picture relative to this letter. None of them had any dealings with Bank Austria. Forget about the fact that the money didn't physically come into our jurisdiction. And if you recall, Waterville wrote a letter to the Ministry of Finance, okay, June 21st, 2006, Stadia projects in Ghana. He says, we are pleased to forward a letter of response from HSBC London as attached concerning the financing of the above-mentioned projects. In summary, the Ministry of Education and Sports signed contracts dated 26 April 2006 with Waterville Holdings concerning the above projects with Waterville American Holdings being the exporter. 1. Bank Austria, as you may be aware, withdrew from the projects. They withdrew. So, apart from the fact that the letter of support meant nothing really in terms of substance, Bank Austria withdrew. So, to be honest, there was no basis for the petition and in order for the petition to be dealt with and for it to result in a certain consent judgment and all those things. The Supreme Court in this ruling on the review called the attention of not just lawyers, but even trial courts.
Yes.
To be diligent and meticulous and vigilant. Am I right?
Right.
To look at the details, things that are brought to them, and not just to say that, oh, because this is this, let it go. The Supreme Court.
And sometimes you ask again, what can the courts do? For example, in the courts in which he got the judgment, when things had happened up to a point, the judge seeking to protect the state
Fantastic.
said,
yes, that's a good
don't
one.
pay all the money,
Yes,
just pay
yes.
this.
Don't
And
need to
then
pay.
all the money is paid.
Yes.
Okay, a few text messages here. This one from Onassis. He says, where in the Supreme Court judgment did they state that Woyome didn't have a contract? What did the Supreme Court nullify on the account that it did not go through Parliament? What is then to go to Parliament? What did the Supreme Court nullify? My brother, I invite you to look for those two judgments and read them carefully. That's all I can say for now. This one is coming from a lawyer. He says, Masa, read the Court of Appeals decision. It is not English. You should read it. It is law, not English. So it is, like I said earlier, a question of technicality and not what our emotions, how we feel emotionally about it. This one says, it is good and refreshing celebrating our women, but it seems politically their performance is below average, and refers to Betty Moldridrisu and the Woyome scandal, Loretta Lamte having been booted out of the Shraj. Okay, all right, so we pray that you lift up your game. Ansa Obofo in the UK. Thank you very much. You know why I didn't read the rest of what you sent? I will not be a conveyor belt for that. Let's stick to facts.
But last point.
Yes.
Yes, it's true. The Court of Appeal thing is written in English. But it's law.
Yeah.
But we've had instances where Court of Appeal judgments have been overturned, even though they were not English, they were law.
Okay. Okay, Nicholas Abose. Nicholas is sending from Abose Kai says, Samson, I want to know if Woyome's case, okay, sometimes these technical problems. All right, I'll get that message and read it to you. And this one from Samuel Bryan says, Samson, some were shot and killed by the PNDC and its forebears or whatever for assessing personal loans which they were legitimately entitled to. But in the case of this era, under the same NDC people, the situation is different. They rather create loot and share, which amounts to nothing but plain thievery. How therefore do you expect this current PNDC government to jail Woyome? Well, the fact that I know them, the Attorney General is pursuing the case with all the muscle and the skill that she can master. Well, okay, so I'm trying to get the problem sorted because we have a little technical issue, and then I'll read your messages to you. I'll not let you waste your money by sending in the messages. We'll take a break. We'll be right back. You're welcome back to Newsfile. This is your most authoritative news analysis show. Is brought to you by the kindest sponsorship of Bank of Africa, strong as a group and close as a partner. MTN, welcome to the new world. And Star Assurance, they've been creating smiles since 1985. And they're inviting you to celebrate 30 years of solid partnership with them. Kofi Atai in Cambridge in the UK says the Attorney General's Department lost the case at the High Court for two main reasons. Let's hear this lawyer. Woyome should have been charged with fraud, and Betty Moldridrisu, Batinodro, Nekwe Tete, and Mr. Asmani, all of these were earlier charged, except Betty Mold and Batinodro, should have all been charged with causing financial loss to the state. The second reason was the shoddy work and failure to call the four people above who were the key decision makers. We should not blame the appeal courts, but the Attorney General's Department. Okay, Nicholas, that's what you say. And some of you make the argument that Woyome is not a public officer, so how can you charge him with causing financial loss to the state? Read the law again. It doesn't apply to only people in public office. It can catch you also if you are part of the system trying to loot the state. This one says, Samson, I want to know if Woyome's case is dead forever, or can it be reviewed? Okay, you sent it late. You heard all the three ladies and Kweku. Some of them, well, they are speaking English, but it is law. Peter Yachi Takwa says, please, will Woyome refund the money or not? Please, I'm confused. Enlighten me. Okay, he's supposed to pay the money. The Supreme Court judgment is unaffected by the criminal process. Ibrahim Kopa in Tamale says, the refusal of the Attorney General and government to parade some of its members in court, such as Madame Betty Modridrisu, Batinodru, and Alex Segbefia, who played a focal point in the whole Woyome case, is enough ground that the NDC government doesn't see corruption as social canker. Needless to say, whatever it is. Okay, the president says that corruption is mass murder, so I think the president believes what he says, and the Attorney General is pursuing it. Can we give them some time? Spike, Ohio, in the USA, says Woyome should be told that the case had just begun. He will definitely pay the 52 million fraudulently paid to him. Michael Amening in the UK says Alfred Woyome should stop bragging and be humble because the 51.2 million paid to him was create, loot, and share spree, and therefore fraudulent. Oliver Bamba Salega says Ghana, our beloved country, is now an error state, and I wouldn't be surprised if we woke up on Monday morning to hear that Woyome's judgment was an error. Okay, so